Thank you very much, Dr. Ishkumar, for so ably and eloquently handling the entire event. And it was real, this entire last 4 hours of whatever we were able to listen to has been a real, veritable feast of ideas and absolutely, something that opens your mind beyond description. Now, we have about 20 minutes for the open house, and we have been receiving a number of questions from the audience. Now, some of the questions are not very relevant to what we are discussing today. In fact, we cannot take up questions which has nothing to do with the subject which is under discussion. So I am not answering or I am not raising those questions which are not connected with arrest. So only a few questions which could be of relevance I have listed out, and I would request some of the speakers to give answers to them. One question which is of very direct relevance is a contrarian view. Mr. Praful Wak has written saying that the general public has a very modest expectations that the accused should at least be arrested in the crimes committed against them. Excesses of the excesses of the Arnesh Kumar guidelines have eroded people's faith in the police and in the judiciary. The police are facing public anger for not making the arrests, etc., etc. That is his question. Now, I would request two persons to answer this, taking about 5 minutes each. May I first request Mr. KP Singh himself to provide his comments, and after that I will request Mr. Kumawat to give his views. Over to Sri KP Singh.
Thank you very much, sir, for giving me the opportunity to answer this question. This question reflects the harsh reality of our criminal justice system, that we are not able to award punishment to the people quickly and sufficiently. That is why people seek solace in custody of a person in prisons as under trials. And this is a reflection or a story of both faulty investigations, lengthy criminal justice system, and again mindset of the judiciary that if there is some lacuna in investigation, acquit the person. As a result of it, people seek solace in sending the person to jail as under trial, because later on, if their case ended in acquittal, at least they have the satisfaction that the person has suffered in jail for some time. And this can be addressed only by ensuring that there is timely justice and adequate justice. For that, we have to reform the criminal justice system. We have to ensure that the cases are decided within months or within 6 months or within a year at the max. And for that, we have to blame the whole criminal justice system. If you try to seek solace in the fact that the person will suffer as under trial in the jail, and that will be sufficient for the complainant, I think that is a wrong premises, and we have to change that mindset.
I agree with your overall views, but the point is that the you know these are like, for example, seeking solace in the criminal justice system. Those kind of changes are far-fetched for the police officer. Is there something that the police officer can do to address the concern of the public?
Sir, the concern of the public may be about their security, that the offender does not harm them further. That can be genuine concern, which the police officer can take proper notice of and can ensure that. And then can ensure that there is speedy investigation, proper investigation, and submitting it to the court. But I do not subscribe to the theory that the person should be sent as under trial in jail, basically to satisfy the ego of the complainant. And more so, sir, in heinous offenses where punishment is more than 7 years, we are giving that right to the people to think that the person should go to the jail. We are not questioning that. We are only questioning the custody as under trial in petty offenses, especially for offenses where punishment is up to 3 years, and where even the complainant can compound that offense after some time, or even where trial is only just for formality's sake, as summons case trial or as summary trial, where even formal charge sheet is not issued, and the person can go scot-free after paying some fine of 2,000 rupees or 3,000 rupees. So far as heinous offenders are concerned, we agree with the proposal of the person who has raised this question.
I fully agree with you. I was only trying to provoke you. Now, may I request Mr.
Yeah.
Kumawat also to give his views?
Mr. Ramchandran, you may be aware that Devarajan had mentioned a case of Ajmer, where a person had been accused, but he was not responsible for that murder. So just to satisfy people, those who are named in the FIR, that they should be arrested. I think grave injustice will be done to the person who has been arrested, because it should be the satisfaction of the IO, police officer, that there is evidence. There is some reason to arrest. We cannot work for the satisfaction of the people, those who are not privy to the evidence that has been collected, or whether there is need for the arrest. So I think there is a dichotomy in this, whether we have to satisfy the people who are ignorant of the evidence, about the evidence, or the need, or the requirement of the law, as per the law, that we have to arrest or not to arrest. So here I think I rest my case.
Thank you, sir. Thank you.
Sir, can I add a small thing, sir?
Yes.
Sir, I think in addition to what Mr. Kumawat and Dr. KP Singh says, it's a time to educate the people also about the police powers. Maybe in the colleges, maybe in the schools, can look, this is the law, this is what police can do, and this is what police cannot do. So maybe that education also will go a long way.
In fact, Mr. Mohan Menon, who is a very eminent educationist, he has a very informative presentation by as an academic citizen. The citizens would request the IPF to arrange such awareness building sessions, etc. He is giving some suggestions like that. Anyway, I'll come back to another question, which is very interesting. There has been a question from Sri Pavan Benival. He's asking whether technology should be used for zero arrest in grave crimes. Grave crimes also. Suggestions to use straps, digital chips, body cameras, high-tech surveillance system, etc. Who would like to take this question?
Mr. Ramchandran, I may like to add something. During our visit to London, Metropolitan Police in London, we were told that people are released on bail because some will be there on his body, or so he's ensure that he's in the town or not, whether he's in his house or not. So there is no need to arrest a person simply because you have to ensure that he remains inside a prison. He can very well inside his house also. We have to only ensure that he remains at the place which we want him to be there, rather than to be only in jail. Open air jail is already, I think, one example where people go out and come back. So they need not be only in a government premise, rather than he can be at his own place, so that he doesn't go and threaten witnesses or doesn't threaten other persons. Thank you.
Sir, I would like to add one thing, sir.
Yes.
Sir, even in the grave crimes, my visits to prison tell me that 80 to 85% of the accused involved in murder cases are not professional murderers, sir. The murder happens because of some particular circumstance, some grouse, some at the spur of the moment decision. So there's no need to treat him as a professional criminal, even if he's involved in a grave and heinous cases. Maybe that distinction need to come in and we need to work accordingly, sir. Thank you.
Very correct.
Sir, I want to add something, sir.
Yeah.
Sir, worldwide, this system of cheap camera, they are used only when the person is out on bail, parole, or furlough. When some serious offense is committed, then initially he is arrested all over the world. He is not let on in the society on bail just in the first circumstances. Therefore, sir, only they are using it for parole, furlough, and bail. But initially, in serious offenses, man should be arrested, investigation should be done, his custody should be taken, he should go to jail. And after satisfying all the procedures, then he may be let on bail. And in that case, such instruments can be used, sir.
Agreed. Agreed. Very nicely said.
Very good. Some of the questions are, the topic may be very interesting, but I am not able to completely grasp the essence of the question. One of the questions is, what is the alternative to 66A of the Information Technology Act? Would somebody like to?
I think KP can respond to this. Actually, sir, 66A has been already nullified by the Supreme Court.
Exactly,
So
exactly. So
provision doesn't exist. KP, would you add something?
Yes, sir. So there are two things. IT Act is a special law, and Section 66A has been declared unconstitutional by the Supreme Court. But in IPC, we have sufficient provisions to book a person who has sent offensive messages or which have done certain act which is already covered under Section 66A. So we can resort to the provisions of IPC and can address the grievances of the victim.
Thank you. 295.
295, 509.
Yes.
There are enough provisions. Even 354A, if it is in the form of obscene gestures or whatever, or even 355D, if it is stalking or whatever. So those provisions can be invoked.
what about the problems being suggested by, there is a strong lobby against the 498A? What exactly is the way forward?
Sir, it's not clear, sir.
498A, am I able to?
Yes, sir. But what is the question about 498, sir?
The misuse of 498A and, indiscriminate arrest of people, etc., etc.
Sir, can I?
Yes.
Sir, this is Satyajit, sir.
Yeah,
I would like to respond on this 498A, sir.
Yes.
Sir, 498A has post Ernest Kumar has undergone some kind of the letter of the law and what is to be done by the investigating officer. All of us were discussing in the morning, but there is another development post Ernest Kumar. In 2017, Rajesh Sharma versus State of UP. Here the court has gone one step ahead, sir, beyond the brief of Ernest Kumar. In Rajesh Sharma versus UP, the Supreme Court has said that there should be some kind of a mediation, and this mediation has to give a report regarding arrestability otherwise of the case. So this is in 2017, something in the line of Jacob Matthews case, that medical negligence case. In medical negligence case, the Supreme Court is clear about the arrest process. Unless there is a report from a body of experts about any medical negligence, arrest should not be resorted to for the medical negligence of the doctors. This is Rajesh Sharma post Ernest Kumar is something close to that. That means there is now some kind of a NGO which will decide about the legality of arrest or not, which has again been challenged, but somebody may enlighten us also about this 2017 Rajesh Sharma case. So it is now going, sir, if you ask me, my opinion, it's almost the court thing that is a civil dispute, should not be part of criminal offense, one. Second is 498A also has a tremendous mischief value as regards as relatives are concerned. Relatives have not been defined in the IPC. And then the court has also interpreted over the years what relatives. The latest about relative is a person who is related by birth, by blood, by adoption. So this is Vasudeva Kutumbakam. That means it has again opened this Pandora's box for abuse by the unscrupulous investigating officer. Anybody and everybody could be a relative now. And roping in so many people also has become a way of taking revenge by the victim, mentioning about 30-40 names. Yes. And this has not been defined. So one thing is non-specificity of relative in the IPC 498-304B is giving tremendous amount of leeway to the investigating officer to abuse that section. Second is the court's view is probably it should be more of a civil litigation, marital dispute, particularly 498. Following this Rajesh Sharma, I mean somebody else may also enlighten about the Rajesh Sharma. I was told has been challenged again in 2017. Sorry, post 2007. Thank you.
So thank you.
Sir, may I
Yes,
say a little bit about 498A?
yes.
498A is a very classic. I think it's whether you're discussing it with the constabulary or with higher thing, it's a very typical thing that abuse of 498A. Unfortunately, but if you look at the other side, so there are no statistics about the exact abuse, that wrong cases were filed wrongfully. And again, the wrongful filing of cases, definitely it is the mandate of the police to file a case based on the information of the incident. Now, what I have found over many years is that that there is an incorrect reading of 498A, which was sort of equated with a dowry demand. 498A, if you read the ingredients of 498A, it is a cruelty by the husband or relative of the husband, amounting to causing grave physical and mental harm to the person. I mean, a very seriously harming the physical or mental health, or making that person suicidal. Now, if you see the pattern of the crimes committed on girls and women in the matrimonial home, if we see the post-mortem reports of girls who died and were being investigated either under 304B or commitment to suicide or murder, they carry a whole lot of list of old injuries on their bodies, old injuries, which are not this thing. So 498A was brought in to stop women from dying, to check the thing, but it became a game for police and lawyers, unfortunately. And it is definitely in that sense that it was misused, because it was applied in cases, and this whole thing of rounding up people, that is again that why the police are not, I mean, they at the time from the informant, they must get the thing that, who has done what. You can't say that my sister-in-law living in Bombay has committed cruelty on me to that extent that I became suicidal. You have to ask. There became a common parlance ki torture karte. Everything doesn't amount to cruelty. right? A certain behavior pattern. So it is also for police to understand properly the ingredients of a crime, cruelty of what. So to bring it into the civil thing, there is already a civil ground for divorce in cruelty, but that is of a much lesser degree. But cruelty which forces a person into suicide, or which gravely affects the physical or mental health, it is deliberately brought into the law. So I wouldn't say that it should be removed, or there has been so much empathy from the judiciary for 498 it false cases, but whenever they're asked who has got the statistics and how were it false, because वो बाद में वो compromise कर लेते हैं. Compromise तो करेंगे सर, वो कहीं तो वो कहाँ जाएगी, उसको या तो उसके वापस घर में जाना है या फिर उसको खत्म करनी है बात, तो वो तो in that sense compromise is thing. But I think this backlash against 498A is quite misplaced to some extent, and we should look at it rationally in the light of what else is happening with other complaints and other arrests also. So we should not carve out 498A for special attention, for that, it's being wrongly done or thing. Let us apply all the other parameters also to 498A case.
So one more question I will take. Unfortunately, we have a very large number of questions, but I'm not able to decipher what exactly they are asking because of difficulties in language, etc. So I am not able to take up some of the questions. There is a question from Nikhil who says that the number of cases registered or registered offenses against the human body are mostly treated as property crimes by NCRB. This is what I understand from what is written here. Do you think NCRB should classify the offenses more clearly? Would either Ramphal Pawar or Dr. Vish Kumar like to answer this?
If Ramphal Pawar is there, let him respond, sir. Otherwise, I will respond.
Please do.
Sir, this question itself is not correct, sir. Property offenses are separately classified and body offenses are separately classified by NCRB. The only thing is there, sir, whenever there are two offenses committed together, suppose one is a property and one is a body, whichever offense carries more punishment, it gets classified there. So suppose there is a murder and rape, if murder has more punishment, it will be taken as a murder. So it will go into the murder. So that must be happening. Otherwise, classifications are very clear and distinct, sir.
Excellent. So we come back to the end of today's discussions. This has been one of the most useful workshops that I attended. I go back enriched tremendously, and I am very certain that every one of us has found it extremely useful. Now, one thing we had planned right in the beginning was to summarize the discussions at the end of it. But I have a feeling that at this stage, summarizing we may not be able to do justice to do that summarizing sitting on this online platform. So what I would suggest is that we go ahead and do the transcription of today's discussions, and at the in a few days time we will be able to write down the broad contours of today's discussions, and then we will organize close the meeting of a few selected officers, and some of the speakers of today could also be invited if they are available. And after that, we can finalize a paper on, based on today's discussions, if that would be acceptable to all of you.
Sir, I have again a suggestion, small, sir. In addition to what you say, sir, we can request each speaker to send us a small mail giving 5 to 6 or 8 suggestions which they come out with, and those suggestions, if we miss during the transcription process, they can be incorporated, sir. So even in addition to the speakers, if anyone else has a suggestion, then if he wants to make suggestion, so we can make compilation separately and then discuss in a physical closed group meeting, sir.
That would be really great. And what we should do is those who are sending their suggestions should use the same subject. That is the topic, the title of today's workshop. That should be the subject, so that we will be able to compile all the suggestions together. What Dr. Ishkumar said is very important, because when we write, some of the ideas may be lost in translation. That should not happen. And secondly, there may be certain points which you wanted to make, but you were not able to make because of shortage of time, etc. So it would be a very good idea if the esteemed speakers could also send a very brief, in fact, you can have, bullet points. There is no need to write very elaborately. Just write the bullet points and we will work on them. And we will make sure that we prepare a monograph on this topic based on all the suggestions that we get from the speakers, as well as other esteemed partner, people who have participated in today's deliberations. Thank you very much. It was a great show. I wish all of you the very best, and thank you very much for sparing the time. It was a very interesting experience.